Hi, check, check, check. Good afternoon, everyone. Welcome to the side event on the role of incarcerated individuals in implementing the Kyoto Declaration. Welcome to everyone in the room and also those online this afternoon. My name is Tejal Jesrani. I'm a program officer in the Research and Trend Analysis branch here at UNODC, and I'm very, very pleased to be welcomed by colleagues from NYU's Bernstein Institute for Human Rights and the Jailhouse Lawyers Initiative for the first time at the UN today. So we're very pleased to have our guests here today. Maybe we could put up the presentation. Thank you. So when we were thinking about how we would frame this side event, we went to the Kyoto Declaration, which is the outcome document of the last Crime Congress on crime prevention and criminal justice that took place in 2021 in Japan. And in that outcome document, the member states endeavored to take the following actions on rehabilitation and social reintegration, as well as access to legal aid. So with regard to rehabilitation and social integration, member states agreed to promote a rehabilitative environment in correctional facilities as well as in the community to facilitate the social reintegration of offenders. And with regard to access to legal aid, states, parties, and member states agreed to take measures to ensure access to legal aid, as well as the collection and sharing of data and the networks of legal aid practitioners. So we wanted to focus our interventions today on those specific paragraphs of the Kyoto Declaration and how incarcerated individuals can really build the capacity of states to enact those in better ways. So I'll be presenting first on the UNODC pilot research, which integrates the lived experience of incarcerated individuals to create better rehabilitation policies. And this was a research that we undertook in 3 countries between December 2019 and February 2020 in Albania, Thailand, and Czech Republic, with a focus on the experiences and perceptions of incarcerated individuals. We included a total of 216 individuals in the focus groups, and we went to 9 prisons in those 3 countries. Here is a breakdown of the gender representation in our focus groups. And in each country, we really tried to overrepresent women in the focus groups in order to compensate for the historical underrepresentation of their voices in this types of research. So we focused our research questions around the 3 following topics. Why do individuals return to prison? Do incarcerated individuals feel that they are receiving the services they need to stay out of prison? And what observations on incarceration and recidivism can be integrated to create better rehabilitation policies? These were the main topics of our focus groups in each of the 3 countries. And we started each focus group with the question, why have you come back here? And that was how we opened the discussion. And in each country, by around the third or fourth day, we really realized that we were hitting certain themes and emphasizing and hitting a saturation of the research. And that helped us to create really direct and concrete policy implications from the research. And they generally fell into three main topics: financial struggles, lack of accommodation in social networks, and corruption in the justice system. So here you can see some quotes from some of the individuals that were in the focus groups. If you are released and all your money goes to creditors, you are not looking for a normal job. This is about financial struggles. In the social networks area, I had no place to go. I couldn't go back to my family, so I went to my friends' drug sellers. And then regarding corruption in the justice system, the police have to fill in the statistics. When something happens, they go back to ex-offenders. So these are really insightful commentary on the way that the criminal justice system works and the ability of offenders to rehabilitate and social reintegrate as well. We also circulated a paper questionnaire at the end of each focus group for each participant to fill out. And so we got some quantitative data from those answers as well. And we asked in that questionnaire for the reasons that people returned to prison, and they generally fell into three sort of buckets here: social networks, unemployment, and conditional release violations in the case of Czechia. So that echoes some of the comments that you'd heard in the last slide. We also asked the participants to reflect on the education, training, and skills development that they received in prison and how useful these were to social rehabilitation and reintegration after their time inside. So one said to us, "I started the vocational school. I never attended the course, but I got a diploma. I saw the attendance list. My name was checked every day. They are just watching videos. It is a fraud. They don't have textbooks or a teacher. If you show the certificate, no one cares. It doesn't have any value. It has the village name on it, and there is nothing here but the prison." And then another one said, "There are many good programs in prison, but it is up to us to take advantage. Building skills, furniture skills, electronic skills are all good. Shoemaking, detergent making are not good because the certificate is from the corrections department. Some others come from the labor department. Training groups can include 100 people at a time." So here you see incarcerated individuals reflecting on the usefulness of the certificates that they are getting and the fact that they feel that some of these training programs are actually not for them. They're actually for the prison to show that they're doing something, and they're not really designed for their needs. So this is a really important observations. We also asked the inmates if they were receiving the services that they needed to stay out of prison. And you can see here that the majority in Albania and Czechia said that they were not. In Thailand, it was about half yes and half no or I don't know. So there's a more mixed response in Thailand. But I should say that in Thailand, they actually had more training and education programs than in the other countries as well. So you can see already that it's an improvement. Then we asked really general questions about reflections on incarceration and recidivism, and got a lot of broad viewpoints from the participants. One of them said, "The real gangsters are outside. Prison is for the poor. After 3 to 4 years in prison, there is so much fear even to go shopping. How will they perceive me? They look at you with disrespect. Once you go to court or to the probation office and they see repeat offender, they don't listen to you at all. There is no reason to try again because they won't listen anyway. You stop trying. The most difficult thing is my will, to overcome my will, to be strong and to refuse the temptations." And the last one, "If I were in charge of the prison, I would improve living conditions so that prisoners can focus on rehabilitation." We also asked in the questionnaire some about the subjects of reflection during incarceration, and you can see from the answers here that many prisoners reflected on their faults during their time of imprisonment. This is a question, brings up questions about whether or not the correctional facilities are actually taking this willingness of self-reflection into consideration when they design their programs. If they're channeling this desire to self-reflect into good areas and into good energy towards rehabilitation and social reintegration. So just quickly, the key findings of the pilot research. So as I said, we hit saturation around day 3 to 4 in each of the countries that we visited during the pilot research. So that really showed to us that the consistency in the responses from incarcerated individuals can show that effective policy at the national level is really within reach and can be, and that these examinations and explorations can really be used to develop evidence-based policy. The lived experience of incarcerated individuals can be an integral and is an often missing element of developing evidence-based policy for supporting rehabilitation. As you could see from the slide, most incarcerated individuals reported that they were learning few skills to assist their return to society and that they really needed better preparation to make the transition from custody to community. And then the last internal sort of finding was that more targeted research was needed. This pilot was very much an exploration, a broad exploration. So in the next phase of the research, we will be targeting different populations and asking more targeted questions to really create better targeted policy on these issues. That concludes my presentation. Thank you so much for your attention. And I have the great pleasure to pass the floor to Jhody Polk, the founder and CEO of the Jailhouse Lawyers Initiative. Thank you.
Thank you, everybody, for having me. It's a pleasure to be in the space. And before I get started with my presentation, just wanted to connect with everybody in the room and with folks online if you are able to join in. And just by a show of hands, and if you're online, feel free to use the availability to buttons on your screen to just be able to raise your hand. But was curious around who in the room has heard the term jailhouse lawyer before. You can just raise your hand. Yeah, awesome. And does anyone in the room, does your country have law libraries in the prisons? Perfect. And do you know what legal empowerment means? Okay, good, good, good. All right. So again, I am Jhody Polk. I am the founder of the Jailhouse Lawyers Initiative, as well as I am a formerly incarcerated jailhouse lawyer. In 2007, I was sentenced. When I was 23 years old, I received my first felony conviction, and was sentenced to 8 years in the Florida Department of Corrections. And during my incarceration, I was assigned to work in the law library as an institutional law clerk and was certified through the institution as a law clerk, who are also known as jailhouse lawyers. For myself and for many other women, it was during our incarceration that we understood for the first time just how the law actually impacted every part of our lives. And we lived a life completely isolated from the law before our incarceration. As a law clerk, I assisted 1/4 of the female population, and I was a law clerk to women in solitary confinement, the medical infirmary, also in the women in death row. And in addition to assisting women with their legal issues, I taught the law, translated the law, and together we learned how to use the same laws that was used to prosecute us to liberate us. A lot of times people think that jailhouse lawyers are law clerks that we're only doing post convictions, but a lot of the work that we were doing was also immigration. It was also family, civil, as well as helping people to protect their constitutional rights while incarcerated. Our liberation was not just limited to our release from prison. Our liberation also came through knowing the law and being able to use the law while we were incarcerated. While studying the law and using the law as a jailhouse lawyer, I discovered my legal identity and adopted a respect for the law. It was in the prison law library, that I began to dream of becoming a lawyer. And I couldn't understand why no one had ever taught the law to me or talked about the law with me before. I was committed to getting a law degree so that I could give the law back to the people in my community. After my experience of incarceration and coming home with my dream of becoming a lawyer, it was my experience as a jailhouse lawyer that motivated me not to give up and return back to prison when I faced discrimination as a woman of color and being labeled as a felon with a conviction in Florida. I used my knowledge and my love of the law to protect me and my children from unfair housing policy, navigating employment, and to protect my human right to education, peace, and to participate in government. Due to many barriers, I have not yet achieved my goal of becoming a lawyer in the US. However, in 2018, I was the recipient of the Soros Justice Fellowship through the Open Society Foundation, which allowed me to launch the National Jailhouse Lawyers Initiative at the Bernstein Institute for Human Rights at NYU Law School. And I created the Jailhouse Lawyers Initiative for myself and for other incarcerated legal workers. The Jailhouse Lawyers Initiative has three main goals: to build and support a national network of former and current jailhouse lawyers. We also co-develop and teach legal education and empowerment trainings for incarcerated people, and we raise the visibility of jailhouse lawyers as human rights defenders and essential members of the legal ecosystem in the United States. JLI is rooted in legal empowerment. Legal empowerment is a human rights methodology that recognizes that the law belongs to the people and at the heart of justice is people. Through legal empowerment, we're able to humanize justice systems, institutions, and organizations, as well as legal empowerment recognizes that people have to know the law in order to be able to use the law, and through using the law, we can shape and transform the law together. Some examples of legal empowerment is community paralegals, mediation, know your rights training, and community-driven litigation and campaigning. And when I talk about community paralegals, I'm not thinking about paralegals in the way that we imagine them as secretaries to lawyers, but seeing paralegals as community organizers, individuals who live in the community, are from the community, who have a knowledge of the law and can be a bridge between communities and the law. One way that the Jailhouse Lawyers Initiative incorporates legal empowerment into our practice is through a three-strand core method of organizing jailhouse lawyers, law students, and institutions together. JLI is a national organizing body of over 500 members, many of who are serving life in prison, and law students who create bridges between the prison law libraries and law schools through shared learning and collaborative participatory methods. We use legal empowerment to build relationships between the institution and between jailhouse lawyers and future lawyers, sharing our legal knowledge, experiences, practices, and communities with one another. We are able to strengthen the legal ecosystem and break the cycle of incarceration from the inside. Although jailhouse lawyers are invisible, jailhouse lawyers are community paralegals in the United States. Oftentimes, we imagine the cycle of incarceration beginning with police and jails, but the reality is incarceration begins and ends in our community, moving through the criminal justice system. Jailhouse lawyering begins in the post-conviction phase of the incarceration cycle, where public defense ends at pretrial. However, this is a very important position within the cycle of incarceration. When individuals become legally empowered in prisons, we return home with the ability to know, use, and shape the laws that oftentimes are the very pathways that lead us into incarceration. Jailhouse lawyering does not replace or threaten lawyers and legal aid, but empowers the community to seek the law and hold it accountable to protect us as people. Jailhouse lawyers are the bridge to access to justice for many returning citizens. And before I transition, turn it over to my partner, colleague, and dear friend, Tyler, I would like to bring the voice of one of our jailhouse lawyers, one of our members, Brandon from Texas. And Brandon writes, so Brandon writes, we must no longer identify with the terms like inmate or criminal. We are human beings. We are US citizens. That is why I frequently use the term incarcerated citizen. We may be incarcerated, but we are still citizens of this country, and we do have rights. We must never forget that and never be afraid to enforce those rights. When we begin to think of ourselves as incarcerated citizens instead of offenders, we start to realize that the injustices we face on a daily basis are not normal, not warranted, not necessary, and not conducive to our rehabilitation and transformation. As incarcerated citizens, we are aware of our rights as well as the codes and policies that govern prison staff, and we hold them accountable for their violations, but most importantly, we hold ourselves accountable and carry ourselves with an air of dignity and respect.
Thank you, Jhody. My name's Tyler. I'm the managing attorney for the Jailhouse Lawyers Initiative, as well as the acting deputy director of the Bernstein Institute for Human Rights. I'm going to share a little bit about the unique legal structures that allow jailhouse lawyering to occur within the United States, connect some of the work of jailhouse lawyers to what we see in the Kyoto Declaration, and then also talk about some of the challenges that jailhouse lawyers face and how we can help support people that are incarcerated, that are doing legal work and helping to close the justice gaps that we see in our societies. In the United States, there was a series of Supreme Court cases that occurred during the civil rights era, during the height of the civil rights era. Johnson v. Avery and Bounds v. Smith together said that prisons could not prevent incarcerated individuals from helping one another with the law. And it did not go to the fact that people who are incarcerated have a right to an attorney, but they did say that they had to have meaningful access to the courts. Most prisons and Department of Corrections across the United States interpreted this to mean that meaningful access would mean to have access to a law library and access to other incarcerated individuals to help navigate those law libraries. So this is sort of the start of having access to law libraries and the start of people incarcerated beginning to use those law libraries to fight for justice and to fight other legal cases on their behalf. Over the years, we've seen the profound impact of jailhouse lawyering on the US justice system. And oftentimes, these contributions are overlooked. When jailhouse lawyers are helping other people who are incarcerated, it is in the support of pro se applications. And so typically the application will go under the name of whoever is facing a rights violation or bringing their case forward, even though the work will be done by people behind the scenes. Just to share a couple of stories of jailhouse lawyers who have been advisors for the Jailhouse Lawyers Initiative and human rights defenders in their own right. In 2020, there was a Supreme Court case in the US called Ramos v. Louisiana, and this ended non-unanimous jury convictions in the United States. Prior to this ruling, if you had a panel of 12 juries and 10 convicted and 2 did not convict, that conviction would still stand. These laws were still present at the time in a couple of states in Louisiana and Oregon, and the laws were specifically made with racist underpinnings. They were created in Louisiana because of the end of slavery, and they didn't want 1 or 2 Black jurors to prevent convictions. And in Oregon, after a lot of immigration from Eastern Europe, the Jewish population was growing in Oregon, and it was anti-Semitic reasons in Oregon for the passing of their non-unanimous jury convictions. This case was brought by Calvin Duncan. Calvin Duncan was a jailhouse lawyer in Louisiana, and he was incarcerated for many decades. He was not convicted by a non-unanimous jury. His jury conviction was unanimous, but he saw this issue and he started raising it. Him and other jailhouse lawyers helped organize the law library, and they screened every case that came to them that had a non-unanimous jury conviction. And over the course of years, I think over the course of 25 different cases, it was the 25th or 26th case that got brought up that didn't get thrown out on different procedural matters, and was eventually the case Ramos v. Louisiana that ended this in the US. Another story I wanted to share is that of Derek Hamilton. Derek Hamilton was convicted of murder in New York back in the 1980s, and he did not commit this murder. He was not there at the time of the murder, but he was convicted. Over the years, he said that there was false testimony, that there was a false confession, And he knew this to be true, but he had no sort of avenue to present this before court. He organized with other jailhouse lawyers in New York, all who were sort of pursuing their innocence claims. And they realized that of the 7 innocence claims that they were bringing at the time in their local law library in the prison where they were incarcerated, they were all led by the same detective on the NYPD. This was a man named Louis Scarcella, and they realized that there was a repeated tampering with evidence, creation of false testimony, and creation of false confessions. Eventually, he brought his own case and in New York, and eventually he was released. He was exonerated, and so after that exoneration, he also brought a civil suit against New York and Connecticut and won a $7 million settlement because of the wrongdoing of the NYPD and other police departments. And his case established the fact that if you are actually innocent, that is a freestanding claim in New York. So before that, even if you were actually evident and you were able to prove it beyond a reasonable doubt, there was no freestanding claim and you had to have some sort of procedural access. And so he helped sort of establish this new right to action. And also, as of August 2022, 19 cases that the NYPD officer that helped convict Derek, 19 of his cases have been overturned, and those men have been released from prison. And this is part of a wider injustice in the US. Over the past 35 years, there's been 3,200 exonerations in the US, and that's just a drop in the bucket of the number of innocence applications that are being brought, oftentimes by jailhouse lawyers. And then the last case that I wanted to point out was that William Joe Johnson himself was a jailhouse lawyer. He was the one that brought about the establishment of law libraries across the US because of his case, Johnson v. Avery. And so jailhouse lawyers have been playing a very integral role in achieving justice in the US and have been doing so in obscurity. But so we're working to help raise awareness about that. Next, I wanted to talk through just how we see the role of jailhouse lawyers and other incarcerated individuals around the world that they can play in the Kyoto Declaration. First, we see that the Kyoto Declaration is looking to create this rehabilitative environment, both in correctional facilities and in communities. Like my colleague Jhody raised, the cycle of incarceration starts and ends in community, moving through the criminal justice system. And so if we have interventions in all parts of that cycle of incarceration, then we're going to have the sort of rehabilitative environment being injected into all parts of that system. Jailhouse lawyers act as community paralegals. They hold knowledge in communities. So rather than sort of just strengthening up our institutions, if we strengthen our communities with knowledge about both legal identity as well as leadership and peace building skills, that will lead to the rehabilitative knowledge living both in correctional facilities as well as community, because the knowledge will live wherever the people are. There's been a lot of difficulty in legal education in prisons. Prisons are afraid for people who are incarcerated to have legal knowledge. We've seen this through legal trainings that we've attempted to do in the US. We've spoken with other colleagues here at the CCPCJ about similar experiences in Zimbabwe and around the world. And we see that contrary to what prisons believe, when people have legal education, like Jhody was sharing, they start to have a love of the law. They start to see themselves as incarcerated citizens, holding themselves accountable. There's a self-accountability and a positionality towards rehabilitation that can occur when we provide legal training and legal resources inside prison institutions. We also see that if we can invest in people while they're incarcerated, especially for those returning home, they will continue to do that empowerment work, returning to communities, thus being able to achieve the goals set out in the Kyoto Declaration, both inside correctional facilities, but also in the environments of the community. Next, I want to talk a little bit about access to legal aid. We see that the Kyoto Declaration sets out for effective legal aid, and effective legal aid must be accessible, and this is accessible in the vernacular of the people who are trying to achieve it. It must be culturally relevant. It must be physically present, and we see jailhouse lawyers as essential in achieving some of these goals of accessibility and effectiveness of legal aid. Because it's a peer-to-peer exchange of information and knowledge, there's cultural competencies, language competencies, physical presence that is sometimes impossible for even attorneys to provide. And we see this as a rich sort of legal ecosystem that can be provided when we start to invest in leaders within these communities. The Kyoto Declaration also sets out that we must raise the awareness of the availability of such aid. Like Jhody shared, jailhouse lawyers have access to every part of the prison. This includes solitary confinement, death row, and the infirmary. It also is present within facilities. And so if we're worried about the awareness of such legal aid, we must talk to trusted ambassadors. Over the course of the CCPCJ, I've heard other presenters talk about effective ambassadors, and we see jailhouse lawyers as fulfilling that role. The Kyoto Declaration also talks about collecting and sharing data on the access to legal aid, and I think that this needs to be informed by people who are currently incarcerated, like Tejal shared in her presentation. The insights that we get from people that are going through these systems are going to be the best source of information about how the systems are operating in real life. And lastly, we wanted to raise the specialized network of legal aid providers. We see the essential role that attorneys play, but recognizing that the way that people are learning about the law and justice systems is diverse, and that all of the sort of educators and holders of knowledge are part of that specialized network. Jailhouse lawyers as being human rights defenders that are closing the justice gap in carceral spaces. I think they're part of that network of legal aid providers and should be included in those discussions moving forward. So while jailhouse lawyers are doing incredible work, they work in very difficult conditions. We see many barriers that our jailhouse lawyers are facing. There's a lack of recognition. Like I mentioned, they always support pro se applicants, so their names are not on it. And we also see them face retaliation. Oftentimes, the more effective that a jailhouse lawyer or a law clerk is, they will be removed from their position in the law library. They'll be sent to solitary confinement. They'll be transferred to prisons that are further away from their communities on the outside. The facilities have complete control over the lives of jailhouse lawyers, and when facilities fear knowledge, they often take those out on the jailhouse lawyers who are working to protect rights and not break any laws. There's also a lack of resource and training. When the Supreme Court said that there must be meaningful access to courts, they didn't provide any sort of resources for that, and they put that burden of protecting that right back on people who are incarcerated together. And so while jailhouse lawyers have been holding that weight for many years now, they have not been doing so with resources and training. One of the main missions of JLI is co-creating resources and training for our jailhouse lawyers across the United States. But we think that this should also be supported by the institutions that have control over their lives, and that there needs to be sort of accountability for them to do the work that they were entrusted with by the judiciary. Next, there's also a disconnection from the rest of the legal system. We often see conflict between attorneys and jailhouse lawyers. Many times when jailhouse lawyers are bringing post-conviction motions, it's based on reasons around an inadequate assistance of counsel, which I think rubs public defenders the wrong way sometimes. We also see that when somebody is incarcerated, they will have an attorney on the outside, maybe that they've hired for money, and then that person will also be talking to their local jailhouse lawyer, and the attorney won't want to hear anything about it. So there's a real disconnect between the system, and we see opportunities for collaboration, for shared learning, and for mutual assistance. And we would really like to sort of see the transformation of the relationships within the legal ecosystem. And then lastly, jailhouse lawyers, while a lot of them are serving life in prison, a lot of them go home. But when they return home, they don't have the ability to leverage the skills and the knowledge they learned while on the inside. In the United States specifically, there's regulations around the unauthorized practice of law. And while the Supreme Court has carved out a space for jailhouse lawyers and law clerks to work while incarcerated, as soon as they're released, they no longer have this right. So the exact same work they were doing on the inside, they can now be prosecuted for as a crime on the outside, especially as people with criminal convictions. This can lead to dire consequences, including reincarceration and heavy fines. Jailhouse lawyers themselves would say that regulations are fine and that there should be some sort of quality control. But the fact that these UPL laws are overly broad means that jailhouse lawyers can't sort of move towards economic opportunities or dignity, or to reinvest in the communities that they're coming from to sort of provide the legal identity when they return back home. Lastly, I just wanted to reiterate the fact that at the Jailhouse Lawyers Initiative, we really see how jailhouse lawyers and other incarcerated individuals who do have access to legal information are closing justice gaps that we see in our society. We see the role that they function as human rights defenders, and we also see that they face similar persecution that other human rights defenders do, where the powerful institutions that they're challenging will retaliate against them for doing just legal work. And so we really want to raise the profile of jailhouse lawyers and sort of show the incredible role that they play within the American legal system, and also encourage those from other countries to think about the roles that incarcerated individuals in your own country can play if they're invested in and given the resources and knowledge of the law. And with that, I will conclude my portion. Thank you.
So if there are any questions from the audience, we'll be happy to answer those now. Or from online, anything? Any questions? Please go ahead.
I had two questions. My first is, Jhody, you talked about being able to go to places basically like PC, right? So whether it's solitary or death row. So my first question is, how did you manage to get permission for that? And then my second question is, have you guys had trouble getting trust from people who are incarcerated when you go in to sort of first start these educational programs?
Yes, and so as Tyler was presenting, it is your constitutional right to have access to the courts. And so everyone in the prison has the right to a law clerk and the right to the law library, even if you're in the infirmary, solitary, or death row. So as the law clerk, it was my responsibility to make rounds through those places and to see, right, to at least show up and see if anyone needed help. And so one of the ways as a law clerk, how innovative approach that I used in those spaces, because even for, there was a woman who was on death row while I was incarcerated, and while she had a team of attorneys fighting on her behalf, the communication and understanding of what the process she was going through, she was not receiving that information. So even bringing research skills into death row and bringing the law library to her, as well as helping women understand how to ask legal questions, how to question the law and find themselves into the law. So it was a part of my responsibility, as well as would like to point out that jailhouse lawyers are the only adults other than correctional staff that also have access to youthful offenders, who are incarcerated in adult prisons. And so we'll also see the youth and be able to, first of all, connect with them, right? Which is so important because they're isolated from the general population, but also help them to understand what their rights were as incarcerated youth and to be able to teach them the law. And because they were isolated from the law library, also helping women to understand how to utilize like the request forms and utilize the internal mail systems as well to be able to engage the law library and gain access to the law. And for our experience on the receptiveness of people inside, they're asking for the information, for the knowledge. We do a very good job of organizing. Everything that we do at the Jailhouse Lawyers Initiative is a request from our membership or with our membership. And so they guide us. In the early parts of creating JLI, we sent out a 32-question survey, especially being nationally focused. We recognize that it's different regionally, it's different like within different states and different areas, as well as women and men experiences are different. And so in addition to telling us who they are and what their needs are, we also work with jailhouse lawyers to identify what areas of the law that they want to know. So in addition to the trainings that we teach on the inside, we also create national modules and toolkits that go out through our newsletters that we actually create with jailhouse lawyers as well. So they request and let us know what's most important and what's needed. And then we as an institution and non-lawyers, formerly incarcerated jailhouse lawyers and law students work with folks inside to be able to bring that legal knowledge to the inside.
I'd rather have a comment than a question. This was a really great presentation. And I'm a lawyer. I'm licensed to practice in New York State. And I know how difficult it is to obtain a license because you have to be upstanding citizen. So if you have a record, it's incredibly difficult to obtain the license. But I have been practicing in Kenya for the last 8 years, and I work on the continent. And the role of paralegal and the jailhouse lawyers cannot be, underestimated. It's without them, a lot of the poor minorities, marginalized communities on the continent would go nowhere. So now that you are out and you have this initiative, I would highly encourage you to work with people like me who are open to the ideas to work with jailhouse lawyers or understand the power of the paralegals to actually spread the news on their communities in terms of what are your legal rights. And my mind kept going in your presentation. You're out, but in Florida, you technically still don't have the right to vote, right? So there's a lot of things that you can use, learn that you have learned or distribute to the prisoners to use on the outside, including getting your basic right to vote back in many of these countries and prevent further violations of the rights that often happen in the US. So thank you for the presentation.
And I just had to share part of one of my proud accomplishments as a formerly incarcerated jailhouse lawyer was I actually worked on the campaign to Amendment 4 in Florida, and we did restore the right for people with felony convictions to vote in Florida. So I was the Central Florida organizer on Amendment 4. So people with felony convictions in Florida can now vote, and it is very important. And a lot of what we do at the Jailhouse Lawyers Initiative is bringing what's happening on the outside to the inside, recognizing that there's a whole justice movement happening on the outside, but there's a justice movement happening as well on the inside. And how can we as organizers connect both of those movements? So thank you for that reflection.
One other thing that reflection brought up for me is that there's a community of organizations that are already doing work similar to the Jailhouse Lawyers Initiative around the world, including in Kenya. Justice Defenders is working with prison paralegals and doing legal education in prisons. Advocate is doing it in Sierra Leone, and we've been meeting with some organizations around the world. And so in as much as thinking through strategies of what does it mean for incarcerated individuals to be part of these justice movements and justice policy conversations, there's organizations that can be touch points for that around the world. So
Yes. That's the legal empowerment way. I love that made that offering. To me, when we talk about a three-strand cord, we recognize that this is movement lawyering, right? When jailhouse lawyers, when lawyers and law students, right? Future lawyers, when we can come together and do it together. So yeah, this is legal empowerment, as well as how we learn from other countries and other organizations as well. We don't have to do it isolated.
Hi, so I'm from the Thailand Institute of Justice. I think some of the research presented earlier looked very familiar. I was just wondering, unfortunately, I couldn't make it in time for the beginning, but you mentioned that there's a sort of phase 2 coming with a number of different areas and different countries you're looking to expand upon. Could you perhaps elaborate slightly? What criteria did you use to decide which jurisdictions to choose, but also what issues within those jurisdictions did you like to focus on? Because I noticed that the areas are different for each different jurisdiction as well.
So the way that we choose the jurisdictions is in the second phase now that we've been thinking about where our impact could be felt the most, where we have already a sustained presence on the ground. So in terms of our field offices and where we have good connections with the governmental authorities, because we develop all of the research in collaboration with the government. And because we're still somehow a very small project, we really want to make the impact as big as possible. So we ask them, we collaborate with the government and with our field offices on the ground to understand what is the situation of research already in the country in prisons, and how can we add to that in the way that in the best way possible, essentially. So that's how we make the decisions. And in terms of what we'll focus on, yes, in Nigeria, what we did, that's the first field work that we completed in the summer. We really wanted to focus on the connection between rehabilitation and social reintegration. And so we envisioned with the prisoners in the focus groups what success would look like for them on the outside. And we tried to ask them to go with us on that journey of desistance and how that would look like for them. Thank you.
Thank you very much.
Are your modules available online? Like if I go to your website, or how would I get them?
So they are not posted online right now. One of the works that we're doing at the JLI right now is launching a new project Flashlight that should be out early next year. So our correspondence with our membership is via the mail. And so we have over 1,000 letters from our members sharing their experiences of doing legal work while incarcerated, and also sharing their ideas around policy and legal change that needs to happen. And so we're building a website to host that database of letters so that it can be part of conversations outside of the prisons. And we'll also have our national modules on that website as well. But if you would like to reach out, come talk to me after the presentation. I can give you my email, and we can share some of the modules we've created. Those spread the gamut from intros to legal research and writing. We've just finished a module on bringing innocence claims in the US. And we also have a practice manual for incarcerated individuals on international human rights and advocacy. And there's my email address if you want it.
I also apologize for being late. My name is Rafael Barreto. I work at UNODC in our office in the Philippines. And what caught my eye on the part of the presentation I was able to watch is that the legal system in the Philippines, as being a former colony, as one would say from the US, is extremely similar. Even the parole law currently in place was approved in the 1930s by the US Congress. So the connection is very strong. But I just wonder, in terms of clarification of terminology, in the Philippines, it is understood of paralegal as a jail officer who has the role who's not a lawyer necessarily, could be, but to sort of connect the PDLs, as they call it, persons deprived of liberty, with the courts and sort of give that information. But I understand that it's a different concept where the person incarcerated would have sort of that leading role. So my question is two, actually. One is whether there is a legal definition or there's any formality in the way that this is framed. For example, the role of what the jail staff is and what would be the sort of the role that the person incarcerated would have. And if you have a similar system in the US that could inspire some change back in the Philippines as well. Pretrial detention often takes 10, 12, 15 years. In most cases are dismissed for lack of evidence. So there's a big issue on the legal side for pretrial detention and lack of bail. It's more complex, but it's mostly rooted on American roots because the legal system drew from that back then. No? But anyway, any sort of that idea of how it compares might help us as well. Thank you.
Yeah, so to answer your first question, each of the prison systems is run by its own state. And so there's sort of the overarching right. So the meaningful access to the court is applicable to all states, but interpretation of that is dependent on each Department of Corrections. So we have membership in 50 states and the federal system. So that's 51 different sets of laws you're navigating. In some states, the prison law library is run by a law clerk, so an incarcerated individual. In other states, the prison law libraries are run by Department of Corrections staff. Typically, the Department of Corrections staff is not a lawyer. I don't think I've ever seen an example of that. And oftentimes, even if there's a Department of Corrections staff person assigned to the library, there will be incarcerated individuals that are sort of the main sources of legal knowledge in those spaces. In terms of shared experiences for the Philippines, I think my main intervention would be that if it's taking 10 to 12 years for sort of pretrial detention, I think looking and seeing the people that are living in pretrial detention, if there was a certain set of information that would be helpful in sort of moving their cases along and seeing how to make sure that that information is living within the institution of the jail or prison where they're being held. That once people who are inside with sort of no pathway forward have some information to move forward with, they're going to be sort of the most rigorous advocates with that information. And so thinking through what would it mean for information about moving pretrial phases forward for the people where the movement isn't happening, that could be a starting point.
To also add to that, thank you. And to also add to that, when I came home and was unable to, become a lawyer and practice law, one of the movements that I joined in the United States is called the Participatory Defense Movement. And it is a movement of non-lawyers and family members at the pretrial phase of the cycle of incarceration. And so through non-lawyers educating the family members and walking with the family members through the pretrial phase to get the best outcome for their loved ones. And a lot of times what that looked like is working with the public defender's office to be able to facilitate communication, build relationship, as well as we saw that where public defenders don't sometimes have power because there's like no relationship in community, when community is involved in the process, we could be supportive in, even educating witnesses on what the procedure looks like or what the process is so that people wouldn't be afraid to talk to public defenders or afraid to actually interact with the court, or to be able to open up a bridge for the public defenders and investigators to come into our community so that they could do, substantial investigations or get the information that they need. And as well as we show up in the courtroom, right? And we made it our own place and we humanized our loved ones inside of the court. So that's a way that also a lot of jailhouse lawyers, formerly incarcerated jailhouse lawyers who can't participate in the traditional way that the legal systems, we interrupt at the pretrial phase through participatory defense methods. And in the United States, there's almost a hub now in every state, and we work alongside the public defender's office to make sure that incarcerated loved ones get the best possible outcome. Yes.
So I'm sorry to say, I think our time is up here, but if anybody has a further question, we can meet outside and you have our contact information to reach out in case there's something else. And thank you so much for your attendance today. And have a great rest of your stay. Vienna.